floor is yours, Martin.
All right. Thank you, Chad. Thank you for being here. I am going to, spoiler alert, I'll tell you how to avoid lawsuits. This is a two-word way to avoid AI related lawsuits, and you're going to say them, it's a repeat after me. The first thing is impact.
Impact.
The second thing are contracts.
Contracts.
So I'm going to unpack how those two words represent the trouble we have in AI and contracts, all that litigation. If you want the black letter law on this, go to buckley-law.com. I have an article on all the legal problems, and I update that periodically. Dawn can give you her card, and she can sign you up to our newsletter as well. And I do have a sign-up sheet that I'll circulate. The first thing you have to know about AI is it's human behavior driven. It is pattern seeking. That's all it is. It's not magic. It's not a religion. In 2017, I wrote a book called Negotiating in the Technocracy. If you get Kindle, it's free. It's on Amazon. If you want a hard copy, I think they charge you something for it. But in that book, I talk about how every wave of technology is seen as magic or religious or fearful. And that's what you're seeing with AI. And people think that the laws no longer apply with new technology. Spoiler, they do apply, and you will get in trouble if you think that the new technology means the laws do not apply. I want to talk for a moment on some research you may have heard about that was done at the MIT Media Lab on our brains on AI. So they had 54 people, 3 teams of 18 students aging between early 20s to 35. They broke up these teams, and each one got a different task. The first team couldn't use AI or any computers to write a research paper. They had to use traditional methods. The second group could use a search engine like Google. The final one could use AI. They actually used ChatGPT. And then they did brain scans of these people on these subjects on the type, how their brains made neural networks, myelination, pathways that we consider critical thinking and intelligence. First group, their brains lit up with no technology. A lot of neural pathways, a lot of memory, a lot of long-term memory built with doing that research paper. The Google group, the search engine only group, their brains were kind of motley. There was some activity. The ChatGPT group, it was black. There was no critical thinking, no activity. The thing about AI, you have to know, it's a great helper, but it doesn't make you smarter. Does anyone know what the Dunning-Kruger effect is? This is the psychological thing where if we have a little bit of ability, a little bit of knowledge about a topic, we kind of think we're experts on it. And we see this on social media every day. A little bit of information, and you think you can write a big paper on it. That's one of the phenomenons with AI. And that's how people, quite frankly, get over their skis using the technology and asserting themselves and losing their professional licenses when they get over their skis and relying on a technology that is a great aid. It's huge, it's powerful, it increases productivity, and that's the way. And I'm very positive about AI, but you have to understand the market and everything that's going on and how it's sold. 2 years ago, there was the latest version of ChatGPT was released. It's so powerful. We're only going to release it to a few companies because it's going to tear everything apart. And that got a lot of attention, got a lot of market capitalization for OpenAI when they did that. At that time, technology people will know this, there were basically 10 to the 8th floating point instructions available 1.5 billion about. The frontier right now is 10 to the 25th. That's a septillion floating point operations. So the compute of AI is really big. And if you've heard about Stopheles, this new super AI, it's going to crack every system. It's really bad. And Anthropic is saying, oh, we're going to release it slowly, and we're going to give copies to the big tech companies so they can prepare for it. But it doesn't pencil out. If you wanted to patch every vulnerability in every system, you'd have to literally shut down the internet for about 6 years. Not going to happen. But what it does is Anthropic is signing more enterprise clients than ever. Why? Fear. It's not to be feared. We don't know where it is. And there's two theories on how this is regulated, this fear. One is kind of what the European Union has done and what California has done. Basically, the European Union led, and they basically shut down essentially all AI development. You really can't, you can do very little in the European Union without breaking the law, which I think has doomed Europe to being the most awesome museum on the planet forever. The other side of it is, the federal level. We don't know where this is going, so we're not going to regulate AI specifically and see where the technology develops. California has kind of taken the EU model whereby they are really restricting what you can do with AI. That's why there's a lot of outgoing companies from California. Colorado is another heavy regulator, and so is New York. Which approach is correct? Well, one theory is we need these special laws. Another theory is we can use existing laws. People are getting sued on existing laws, and I'll tell you what those laws are. People who, there are narrow use cases where it's smart law. For example, in 2027, there'll be a new law effective in Oregon, which looks at chatbot and suicide ideation, right? So you have to have some type of oversight where you can catch people using a chatbot who it's leading them down to suicidality. And you have to actively prove that you have safeguards in place because some people have sadly taken their lives on chatbots. But that's happened before with technology. Does anyone remember when Ozzy Osbourne got sued when sadly a teenager took his own life after listening to a Black Sabbath song? That happened. And then you got regulation and typical, but that technology was FM radio, right? This technology is AI. It's all tragic, but bad facts make bad law. You have to, for example, I totally support what Oregon and Washington have done. I'm not so sure about these other. California's laws suffer because they're so general. Virtually anything you do with AI could require state oversight, and that may or may not be a good thing. But where are people getting sued? They're not getting sued on the new AI laws, some of which won't take place until 2027, some of which are in place now. But people are getting sued on the first word I told you was impact of what AI does. The famous case, it was a Title VII discrimination case, civil rights case, and that involved an IT company whereby you had a load of old resumes, and they did a first in, first out type of resumes over years, and they would hire from the first in. That set of data is called data bias, data selection bias, data availability bias, whereby all the candidates for those IT jobs were male because in the years they selected that group, there were almost 100% male IT worker job applicants. But now it's actually closer to 40-60, if not 50-50. So someone sued and said, hey, how come dudes are always getting the jobs? They sued and they found that was a disparate impact of how they selected the data, that AI that did resume searching. So you have to think about the impact of what you're doing. That was an HR application. The next big lawsuit, which you have may heard about, New York Times v. ChatGPT and Microsoft and everyone else, that involved copyright infringement, whereby the New York Times said, we have these investigative reporters, we report this stuff, you need a subscription, you guys are crawling all over us, and training data of ChatGPT is basically New York Times very expensive reporting, pay us billions of dollars. But there was something involved between that claim and a defense that OpenAI had, and that was the second word, contract. ChatGPT's defense was, in order to get that data that you got from us, you violated our terms of use on our website, which is a contract, and that was their defense. So still in litigation. Who knows where that, but that's just copyright violation. Copyright violation generally protects the copying, distribution, transfer, transmission of expressive content, an article, and they are saying AI does that. But so too, when you read a book, and if you read several books, you can synthesize and publish it, and that's not copyright violation, as long as you have the copy. And that's the Anthropic case. So Anthropic actually bought books, took the spine off them, and scanned them physically in to do a lot of its training data. But there's a certain set of books they did not. They don't know how it came into their training data, and that court case they settled. They were innocent on the stuff they actually bought, and they were tagged on stuff they didn't have the receipts for. So it was kind of a mixed result. That's copyright law. Another law, and this is very important for companies, is trade secret law, trade secret waiver. This involves when you have a great idea, it's confidential information, and you want to innovate a little bit more, get a few ideas from a public search engine. You type it in, it comes out, and you have just waived your trade secret. Trade secrets, anything you do in a public chatbot is considered public information. There's no privacy. So you have waived any privacy right you have, including your attorney-client privilege. Recent case, a client working in coordination with their attorney started to generate some evidence on facts, if you will, to support a case on using AI, a public AI. They handed this factual information, quote, factual information to their attorney. Their attorney tried to submit it to a court. The judge said, where does this information come from? They said, oh, my client used AI. The judge said, you have waived attorney-client privilege because training data is public data. You have to hand that over to the other side. Please do not do that. I'm using some terms, and we're going to talk about training data. Basically, when you prompt, that becomes learning data for the AI, and it doesn't take a lot of cycles. If you follow me on LinkedIn, I publish studies on different universities where they do about AI and how it works. If I have a fact pattern that's unique to you, how many prompts do you think it'll take for that exact same pattern to be replicated in someone else's? What do you think? A few dozen, 100? How many think it's 1,000? What? Less than that? Less than 1,000? How many? Shout out, someone. 10. Very good. 5. So if opposing counsel types in your thing in a public database, your fact pattern, and it comes up, and they find out your prompt, that's not a lot of prompts. That's 5. So it can happen, and indeed, attorneys are getting disbarred for this. 2 weeks ago, there was an attorney in Portland was fined $10,000 by the court for not checking citations. We have AI tools at law firms. They cost thousands of dollars a month but you still have to check them, and they are containerized for, like, Westlaw, Lexis. They're trained on case law, statutes that is within their environment, and it's still not 100%. We have to check everything. We have to. It does compress time and gives people access to justice because we can do things quicker sometimes, but you've got to check everything because even those expensive bespoke legal AIs are not perfect. So I always like to think 60%. If I'm using a public AI, 60% of it will be pretty good information. 40% will probably have to be not relied on. And which one is? Well, you need to use something you have, which is experience, right? That prefrontal cortex, that bright part of your brain that the book only and no search engine people at the MIT Media Lab had to do. Experience is still part of AI. AI is a powerful tool. I'm very pro AI, but you have to know that your contracts have got to be reviewed for AI issues, and you always have to think about, as a company, I'm doing something, what's the impact? So once again, what are the two words you need to know everything about AI and the law? And very good. And now I think we're going to do questions. So
yeah, quick. Just if you have any questions, also, please find Martin after we wrap up. We still have a half hour here. Does anyone have any questions?
yes.
You define public AI versus private AI?
Yeah, anything you don't pay for, and even if you do pay for, it is public. So let's talk about that. Here's a sign-up sheet. Firm newsletter. If you want it, you can. And I also this idea of negotiating. So the problem with public AIs, they want to be helpful. It's called sycophancy, where they want to be your friend. I hate when they say please and thank you. I'm like, I just want the facts. Just, you're not a human. Stop it. That is part of public AIs. Public AIs are basically, if you don't pay for something, if you don't pay for a service or product, you are the product. They're getting information. So what's the model? So Anthropic's model is more of an enterprise. They want to do big company. ChatGPT's is consumer. So they're getting consumer data on you, and they're already popping ads. They're going to know so much about you, just like AI is used on Amazon. And they tell me what I want to buy before I buy it, which is very irritating, and not good for the budget. But public AIs are stuff you don't pay for, or even if you do pay for a subscription, and they all have better subscriptions where they give you priority or more data or better tools, you have got to select private. Don't save my data, which is part of the background. You can do that on Gemini and Grok and all that. I still don't trust it. If you have any data, you have to, what they say, anonymize. Don't use any real facts, real people, real numbers. If it's like a financial statement, it's generic, and you take out all the personally identifiable information, sure, use it to do, income statement, balance sheet, general stuff, because numbers generally aren't private, just in the wild. But if there's enough information to link that to a real life and being or a real entity, real corporation, that would have waived that. So that's what I mean by public. Basically, any AI, unless you hire. So a lot of companies are doing, they're like licensing an AI engine rather than develop themselves. And you can do this. You can download Llama, Facebook's thing. And my son actually did it for his computer and trained it on his data. You can do that quite easily, and companies are doing that for an enterprise model where we have a knowledge base of proprietary data that's on our side of the internet, and we want to prompt our engine only to train on data within our environment. It's not going to go out to the internet. Those are private ones. That's what Lexis and Westlaw do. They generally don't go to the wild to train, and all those prompts and information is contained to preserve privilege. And you see a lot of services like that. More questions?
I'm gonna stop right here. So please, if you do have questions, come find Martin when we wrap up because we'll have a half hour until 9 o'clock. At this moment, I'd like to give Martin a round of applause. That was incredible. I could listen to him forever. I appreciate it. With that, I'm going to hand it over to Matt for any chamber announcements.
Thank you very much, Chad. A couple of things I want to bring to your attention. If you work for a technology company, or if you